Item Password case item 16, Kinner Region 47 of 2019.
Which is the petitioner? उस समय भी नहीं आए थे ना?
नहीं.
डिसमिस कर दो. रिस्पोंडेंट इसका स्टेटस पता कर लेते हैं. Mr. P.P. and Roy appear with this way at one point of time. आप हैं इसमें? क्या स्टेटस है केस?
नहीं पता चल रहा मैडम, पूरा प्रयास किया, नहीं नेट काम कर रहा.
एक मौका और दे देते हैं पिटीशनर को, कल डिस्कस करें.
ऐसे पीपीएन राय से हम अपीयर कर रहे थे.
इसीलिए वो तो एब्सेंट होते नहीं है कभी.
नहीं
कोई इंस्ट्रक्शन नहीं होगा सीनियर
हो सकता है
एडवोकेट.
कहीं फ्रैक्चरस हो गया हो, ऐसा भी.
देयर इज अ लाइक्लीहुड. कल कर देंगे डीएफडी. आज एक दिन छोड़ दो.
हाँ निश्चित.
Criminal Revision number 47 of 2019. In spite of repeated calls, nobody is appearing on behalf of the petitioner. आप इनको फोन किए थे? ओंकार नाथ तिवारी को? क्या बोले? Counsel for the opposite party number 2. Counsel for the informant is present. In order to give one more chance to the petitioner, post this case tomorrow.
Item 17, Kinner Region 56 of 2019.
Yes,
Mr. Anurag has already given me updating the
any fresh पता लगे? Mr. शास्त्री, आपको पता नहीं चला क्या स्टेटस है केस का?
नहीं नेट में नहीं आ रहा.
कल के लिए है, आप अपने आईओ से पता करिएगा.
आईओ को अभी बोले
कल के लिए
महिला
रखो.
थाने को.
कोई नहीं आएंगे तो कल उसको डिस्कस करें. Yes. Mr. Anurag Kashyap has given no objection. Who is the? Has anybody entered appearance? And where is he? Is there any stay? No. देखिए ये कागज सब निकल. Nobody appears on behalf of the petitioner. Learned counsel for the opposite party number 2 is present. LCR आया है? Not required. In order to give one more chance to the petitioner, pose this case on 24th April. It has been submitted that Mr. Anurag Kashyap,
Mr. Kashyap, Ms. Supriya Dayal, both of them.
and नाम लिख के दे दीजिए. Have given no objection in the present case. Office is directed to delete the name of the aforesaid advocates from the cause list. Give the names of the persons whom you want to be deleted.
This case from bail list item 2, WPS 3734 of the 2023.
handed over the document for modified.
यहाँ पे तो नहीं है.
Compilation I want to find on last day.
This is more voluminous than your writ petition.
This includes my judgments.
That's right. So you argue.
Yes.
We can't incorporate so lengthy written submissions in my order. So you just argue and you have to challenge the proceedings.
Proceeding action
So-
1, that is the charge sheet. my
So
lord.
you just formulate the points.
Yes. The first point would be, my lord, the charge sheet has been issued by an incompetent authority. By an authority not competent to issue charge sheet.
Just a moment. Let me just complete it. Who has issued the charge sheet?
Charge sheet has been issued by the assistant security officer.
Respondent number?
Sorry, I stand corrected. In charge assistant security officer.
Respondent number?
Respondent number. Six.
This is Assistant Security Commissioner.
Commissioner.
Respondent number 6.
6.
You have not mentioned him as in charge.
Because he has used the word assistant, but I have annexed the letter by which he has been given.
All right. Okay. It has been issued by respondent number 6.
6.
Who could have issued it?
Divisional, the senior divisional security commissioner. Respondent number 5 today.
Respondent number 5. Okay. From where do you say this?
Yes. Now I may invite the lawsuit attention to Rule 153 of the RPF rules.
Yes.
153. Procedure for imposing major penalty. Your lordship will see the opening sentence of the charge sheet, my lord. It says major for imposition of major penalty. रेलवे सुरक्षा बल नियम 87 के नियम 153 के अंदर
No, that's
आरोप को जारी करने के लिए दीर्घ दंड therefore
That's
153. Procedure for imposing major penalty. Without prejudice to the provisions of Public Services Inquiry Act 1850, no order of dismissal, removal, compulsory retirement, reduction in rank shall be passed by any enrolled member of the force, save as mentioned in Rule 161, without holding an inquiry insofar as may be in a manner provided hereinafter, in which he has been informed in writing of the grounds on which he is proposed to take action and has been afforded reasonable opportunity of hearing of defending himself. Well, may I take the lawsuit directly to 153(4), where it is proposed to hold an inquiry against an enrolled member of the force under this rule. The disciplinary authority may order that the enrolled member shall not be transferred. Yes, now your lordship may come to.
No, you have
Yes.
stick to the authority who has
Yes,
issued.
yes.
Which
I
is
go-
the
I go-
relevant provision?
Yes. 153 2.1. Whenever the disciplinary authority have the opinion that there are grounds for inquiring into the truth of the imputation of misconduct or misbehavior against an enrolled member of the force, it may itself inquire into or appoint an inquiry officer higher in rank to the enrolled member charged, but not below the rank of inspector, or institute a court of inquiry to inquire into the truth thereof. The inquiry officer can be a person not below the rank of inspector. Inquiry officer, I am not objecting. I am on the point of conducting also. On the point of disciplinary.
Who is your disciplinary?
But according to them, it is assistant secretary.
According to you, who is the
Number
disciplinary
five.
authority?
I'll come to rule 25 more. That will show me.
No,
And-
first
and-
let us figure out what is your case. We'll
My
come to
case
their
is-
case later.
My case is that
Your case is that respondent number 5 is the disciplinary authority.
disciplinary authority if lawsuits come to schedule 3 matter. That will show matter schedule 3.
So 153.4 is not relevant.
153 as a whole would be relevant matter if lawsuit comes to rule
No, you
25.
can't. You are on the jurisdiction, no?
Yes.
So for this purpose, 153.2.1 is relevant.
Yes.
Okay.
4 is not.
So what do you want to? You want to show the schedule?
No, first I'll take a lawsuit to section 25, rule 25, and then to schedule.
Rule 20. What does it say?
Say, the superior officers of the force, general powers and responsibilities of superior officers. The superior officers of the force shall exercise such administrative and disciplinary powers over the members of the force placed under their command as are specified in Schedule 2 to 4, and such other powers who are conferred on railway servants of equivalent rank by any rules relating to such service and discharge of such responsibilities as are specified in these rules, or may be specified in any directions issued by the central government or the Director General in this behalf. Now you will also become Schedule 2 to 4.
This is relating to general powers.
General power,
Schedule 2.
Schedule 2 relates to appointment, I am not related. Schedule 2 relates to appointment, promotion, confirmation matter, that may not be relevant for this case, but Schedule 3 would be matter. This is so who is my disciplinary authority.
What is your designation?
My designation
At the
I
time
am
of
constable.
constable. Okay. Yes.
But you will also see Schedule 3 matter. First is suspension. What are the powers of Director General? I will directly take your lawsuit to Assistant Security Commissioner by the last column. All under officers and below. He has the power to suspend. Everybody has the power to suspend. But dismissal, if your lawsuit comes to matter, dismissal, no power. The Assistant Security Commissioner has no power. Now your lawsuit, next is removal. He has no power. Compulsory retirement, he has no power. The point I am trying to drive home is that, my lord, the Assistant Security Commissioner is not competent to inflict any major penalty to me. So, my lord, he could not have been my disciplinary authority. Disciplinary authority could have been Divisional Security Commissioner, Security Commissioner, Commanding Officer, and so and so. Now you lost it.
So he could be column number 6.
Yes.
Divisional Security Commissioner. Okay. All right. So
Now you also will come to Rule 151. It defines disciplinary authority.
rule
151.
151. And what is rule 133?
151.
133.
133.
This is suspension. Okay. Rule 151.
151.
That's right.
Yes, 151 disciplinary authority.
151.1.
Yes, the disciplinary authority in respect of any enrolled member of the force for the purpose of imposing any particular punishment or the passing of any disciplinary order shall be the authority specified in behalf of Schedule 3,
That's right.
in whose administrative control the members is serving and shall include any authority superior to such authority. I have shown your lordship from the Schedule 3 matter, the disciplinary authority for the purpose of imposing major penalty would be column 6. Here it is a case where the Assistant Security Commissioner has issued the charge sheet. Your lordship will further see, my lord, I have annexed with the rejoinder, the Assistant Security Officer is basically an inspector who has been given charge of ad hoc Assistant Security Commission. My second argument would be that ad hoc does not have the power to initiate departmental procedure against me. Had it been Assistant Security Commissioner, he had the power to suspend, but in the instant case, since he is ad hoc valid, he could not. That is one of the.
If you succeed in first point, the matter ends.
Pardon, madam?
If you succeed on the first point, the matter ends, because even
Yes,
if
ma'am. Yes.
this respondent number 6 was the authority who has issued you the charge sheet was
Yes, ma'am.
was working on ad hoc arrangement as respondent number 6,
Yes, ma'am.
right?
Yes, ma'am.
Right.
Yes,
So
ma'am.
at best he is ad hoc assistant.
Security Commission.
So irrespective of the fact whether he is ad hoc or he is regular, he is not entitled to issue you the charge sheet.
I've been
So it
successful.
makes no difference
Yes.
whether he is ad hoc or not,
Yes, ma'am.
right?
Yes, ma'am.
That should suffice.
If I succeed on first point, madam, my purpose is served.
That is the only point.
No, then I will come to my lord. The documents have not been furnished to me, my lord. If you lost seat, there are 112 pages which have never been furnished to me.
That will be furnished to you. That is not an issue.
No,
That is not an issue for the writ court to consider, right?
Non-furnishing of documents will prejudice
You
my case.
did you ask for
Yes,
ask
ma'am.
for it?
Yes, I have
Then they will give it to you. What's
I
the big
have
deal
read
about it? As it is, you are not participating in the
No, I have
proceedings.
participated. I have.
But there is an interim
They stay
order.
on final publication, madam, but as the proceeding is going on and I have participated, there is not their case that I have not participated.
Okay. Yes.
Yes. Lord, can you see Rule 152,
152.
authority to institute proceedings? The Lordship has seen 151, my lord, the Schedule
Yes.
3 also, my lord,
Yes.
so far as the authority is concerned. 152.2, my lord, will be relevant for the purpose, my lord, involved in the present case. A disciplinary authority competent under these rules to impose any of the minor punishments may institute disciplinary proceeding for the imposition of any of the major punishment, notwithstanding that such disciplinary authority is not competent under these rules to impose any of the latter punishments. Here your lordship kindly then come to Schedule 3, my lord. So far as the AC is
This is an exception to Schedule 3.
yes, ma'am.
This is an exception to
Yes.
Schedule 3.
151, my lord, the power has been given.
Yes.
So far as that part is concerned, your lordship has seen, my lord, so far as the power with regard to the
Dismissal.
dismissal is concerned, that has been conferred upon the Divisional Security Commissioner, my lord.
That's right.
Column number 6, my lord. So far as the Assistant Security Commissioner at Roman number 7, my lord.
Yes.
Column number 7, my lord, he has no power so far as that
That's
part
right.
is concerned. But my lord, para 5, my lord, reduction in grade, rank or grade. This minor punishment is concerned. Although this is also, my lord, major punishment, but this is also, we can treat to minor, my lord. The power, my lord, has been given to all under officers and below. My lord, this power has been given to the Assistant Security Commissioner, my lord. Similarly, the position with respect to the other minor punishment which has been allowed, my lord, in 7, then censure, the withholding of increment, these are the minor punishment in the column, my lord, 7, 10 and other fine, etc. my lord. Therefore, if at all, my lord, this provision is being read along with Rule 152.2, an authority who has been empowered to proceed to impose the punishment of minor punishment, my lord, he has also been given authority to proceed departmental proceeding, my lord, even for the major punishment, my lord. Therefore, in terms of 152 subsection 2, my lord, the authority cannot be set for the purpose of initiation of departmental proceeding that it is without jurisdiction.
If it is initiated by this officer,
Yes, ma'am.
then at the time of passing the order of dismissal or whatever,
Yes, ma'am.
depending upon the recommendation,
Yes, that-
it can be placed before the
Before the
appropriate
higher
authority.
authority, my lord, who is competent
Suppose,
to do is, my lord.
suppose after initiating a proceeding for major punishment, ultimately it is found that only a minor punishment
Then
is
he
to
will
be
impose it, my lord.
Then he will
Therefore, this
impose
is
it.
the distinction which has
Suppose
been.
the dismissal order has to be passed,
Then
has
it is to
go.
be referred to the competent
And
authority.
suppose this reduction in rank or grade is to be passed, then
Then
he
he
can
will
do it.
pass an order, my lord. That is
So,
the
so
reason.
there is no bar in initiating a
Initiation,
proceeding,
my lord. Therefore,
but
my
the
lord,
order of dismissal cannot be
my lord, your
passed.
lordship will find, my lord, so far as this part is concerned, this has been specifically provided in the rule, my lord. So far as the initiation of the departmental proceeding column is there, my lord. That chapter itself, my lord, 152, 151, my lord, deals with the disciplinary authority, and 152.2, 152, my lord, deals with the institute to initiate proceeding, my lord.
So, under the provisions of these rules, the authority who is empowered to impose minor punishment
He can
is
initiate.
not the same as authority who can impose major punishment.
Yes, that is the provision, my lord. Therefore, my lord, if 151, 152 are being read together, then, my lord, it cannot be said the initiation of the posting is without jurisdiction.
That's all.
Yes, my lord, this is the only thing.
May I take your losses of 152 once again? Authority to institute proceeding. The appointing authority or any authority otherwise empowered by general or special order made. Now let us see who is the appointing authority, my lord. Schedule 2. The Assistant Security Commissioner has no power to appoint. And there is nothing on record to show
So
that
we do not know what is, you have not referred to Schedule 2 so far.
No, we have referred to Schedule 2, madam.
You have referred to Schedule 3.
Schedule 3 was so far as punishment was concerned, madam.
Yes.
But if you are see, madam, 152, who can the appointing authority? Now from Schedule 2 we will get, madam, who is the appointing authority? Appointing authority, madam, the Assistant Security Commissioner has no power to appoint. Then it can be the case of the respondent that there was delegation, madam. There is nothing on record to show that there was delegation of any sort, madam. So, madam, any person subordinate to the appointing authority cannot initiate, madam, in terms of 152.1. Madam, so far as 152.2 is concerned, madam, my senior colleague has relied upon 152.2, madam. Madam, in the case of, in the compilation I have given, madam, the rules of.
You just tell us whether the authority who has issued you the charge sheet has got the power to impose minor punishment on you.
Yes,
He may not.
minor, yes. But the charge sheet is for major.
Charge sheet can be issued for major, but ultimately the punishment can be a minor punishment. There is no legal bar.
My argument would be, madam, when charge sheet.
Do you want to say? Do you want an order to say that even if charge sheet is for a major penalty, no minor penalty can be imposed?
No, that is
That
not.
you cannot say.
No, my argument would be when it is a charge sheet is for major penalty, my lord, it will be initiated. The charge sheet will be issued by an authority competent to impose major penalty, and after inquiry, if he comes to a conclusion that it is a case of minor penalty, he can. But the reverse is not. No. The charge sheet is under Rule 153. I appear, my lord, charge sheet is under 153. 153 says, my lord, what is the procedure I have shown, my lord? Schedule 2, Schedule 3, my lord. Here, no, Schedule 2 I have also
But
shown.
I am sure that you will not dispute the proposition that even in a proceeding for major penalty, a minor penalty
Yes,
can be imposed.
Yes, but then in that case, the disciplinary authority will be an authority not below my appointing authority, madam. He can. A superior can avoid punishment for my minor penalty, but a subordinate cannot. That would be my proposition. So far as 152.2 is concerned, madam, that relates to gazette also, madam. That will relate from my compilation I have given, madam. The rules of the railway board. Madam, if you sees rule 117, madam, it says, madam, I will place.
You see, when there is so much of dispute about the competence of the authority to institute, and you are referring to so many circulars and provision of law, then do you think that the authority who is dealing with the matter has got no jurisdiction to deal with this?
No, madam.
Because no means It is not a case of open and shut straight away to the provision of, once you start referring to the circulars, then I will ask them to consider it. Because there are so many circulars governing the parties. So as long as the act is there, there is no problem.
Yes.
But once you refer to the circular, we'll ask them to consider the point of jurisdiction also. Because it requires the consideration of various circulars issued
Yes.
by the board.
Yes.
Then that should be open to them to consider. There are circulars, contrary circulars. There are so many things which are governing the parties. You see, a point of jurisdiction can also be a disputed question. All points of jurisdiction are not point of law. There are point of jurisdictions which are
Here is the
disputed
case,
questions.
here
There
is-
are
it can be-
delegations.
it can
There
be,
are
madam.
circulars to be considered. Then
It
why
can
don't
be,
you?
madam. Here is the case,
We can
madam.
just observe that you have raised a point of jurisdiction. But this point, if the moment you start referring to the circulars of the board, then you will have to agitate it before the authority, because we are not in possession of all the circulars of the board. We do not know what is the nature of delegation. We do not know what are subsequent circulars, the
Well,
previous
other side has already
circulars.
brought on record the relevant, sir. Therefore, my lord, your lordship is hearing both the sides, so that all relevant documents may be brought on record.
You see, if this is the nature of dispute, as long as you are sticking to the provision of law, I will interpret it. But the moment you enter into interpretation of circulars, we will not enter.
I'm not seeking your lordship's indulgence for interpretation of the clause. It's a clear-cut case, my lord. Who is the appointing authority I was told from Schedule 2, my lord?
Who is the appointing authority?
Schedule 6 Division Commissioner, my lord. Schedule 2 appointing who? The lordship see.
The authority has been defined separately.
But then 151 says, my lord, the appointing authority or any person delegated with the power. But the delegation is not on.
No, which entry are you referring in
Schedule 2, my lord, first entry, appointment.
Yes, appointment.
Appointment. Your lordship will come to the 7th clause, my lord, Assistant Security Commissioner. He has no power to appoint. So he cannot be my appointing authority, my lord. Appointing authority will be Schedule 6 again. Column
Appointing authority will be Schedule 6.
No, sir, not Schedule, column 6. Divisional Security Commissioner. So, well, then now your lordship may, in this context, keeping that in mind, your lordship may see 151,
151 or 152?
152, sorry. 152.1. The appointing authority or any authority otherwise empowered by general or special order.
Yes.
Now, in this context, my lord, I have given you the judgment, my lord. In the case of Satish versus Union of India, in the compilation act,
Page number?
page number 29. Relevant will be para 60. my lord. Para 60, relevant at page 45. Next, please. From the above, it is more than apparent that the rules mandated for the proceedings are that.
This is which High Court? Ahmedabad.
Yes. DB, but DB. From
Which
the,
is-
yes, when
Which provision?
There are paragraphs.
You just shows the facts, and then only we can appreciate the law.
Yes, facts are listed. Similar facts were okay. If you lordship sees, if lordship wants to page, page 31, madam, that is the prayer name. To direct the respondents to caution, say the charge sheet, it is such and such. The order passed by the disciplinary authority, dismissing the petitioner from service, appellate authority, and order dated such and such.
So after all the
But
proceedings,
yes, but the charge sheet was also charged.
That's-
That is the point.
charge sheet has been set aside.
Yes, you will also see now in this context. There are 60 at page 45. There are 16 towards the bottom. From the above, it is more than apparent that the rules mandated for proceedings are that the disciplinary inquiries are to be initiated by the disciplinary authority only. Consistently, the word used in the above rules in disciplinary authority, even rule 152, which talks of appointing authority or any authority authorized or empowered in that behalf to be an authority superior to the disciplinary authority. My lord, it could be superior but not subordinate. Once the relevant rules and Schedule 3 of the 1997 rules provides the Deputy Additional Chief Security Commissioner to be the disciplinary authority for the petitioner who was a sub-inspector.
152.2 has been considered in this judgment.
No.
So they are relying upon
But 152 has been relied.
152.2.
No, you are also see, right?
Where is 152?
152, even rule.
Where is it quoted? Where is it mentioned?
Madam, the last paragraph you will also see. CSCA 7466, CAB judgment 152, which talks of appointing authority or any authority authorized or empowered in that behalf to be the authority superior to the disciplinary.
No, so they are not dealing with 152.2 at all.
They have dealt with 152 as a whole.
No, they are not dealing with 152.2 at all. The narration does not reflect.
Madam, Madam,
If you have to brief,
Madam.
you go home and brief.
Sorry,
Don't
sorry.
stand side by side and start briefing. You
No.
don't have time to brief. You
No,
do
madam.
not anticipate these questions. What is this?
we'll take easy. Madam, my point is, madam, I am harping upon 152. The authority to 152.
You respond to 152.2 straight away.
Madam, that is only with regard to gazetted officers. That in that regard,
When you read gazetted officers into 152.2, kindly read it from the rule itself.
Madam,
You read 152.2 once again.
May I invite your lordship attention to 117 of the rules. It says, my lord, when there is a confusion that the railway route shall be relevant.
So therefore,
Therefore,
it's a hotly contested issue as to whether he has the jurisdiction or not, and various provisions of the rules and the circulars are required to be considered.
Yes, it has to be considered.
Then, in which jurisdiction, how do we decide this?
I have just placed a judgment, my lord, in which says
You see, I am not agreeable to this. I will just simply say that this provision has not been dealt with. That should be sufficient. Any judgment passed by any other high court, I have to consider. That is why I am putting a question to you. Has this particular rule been considered?
my lord, in my view, my lord, according to me, my lord, when the court has relied upon 152, the court has gone through the entire provisions of 152. It cannot,
That is your view, not acceptable, and I don't agree to
the
that.
court cannot read one provision in isolation.
That is why there are provisions of appeal and to Supreme Court, so many things are there. Because we can always err, there is no problem about
Obviously,
it.
my lord, to err is human.
Yes. But this is something I feel that 152.2 is a very different kind of provision which is normally not available in service jurisprudence.
May I invite your lordship's attention to the railway rules? I have an
No, please. If you want to go into multiple rules, then the jurisdictional issue itself is quite a contested issue, and it requires consideration of various circulars and rules and their interplay, and that you can agitate before the disciplinary authority. He will give a finding on that, and then at the appropriate stage you can have a remedy. If you want simple interpretation of this rule, I can do it.
Your lordship may say, he will decide the issue of jurisdiction as a preliminary issue.
No.
That's a
We will not
preliminary
say
issue.
that. You say that we cannot control the disciplinary authority to do this. He will decide
But
everything.
this will go to the root of the matter.
If it goes to the root of the matter, the entire order of punishment, if any imposed upon you, will be set aside, will be vitiated as void ab initio. You should have so much of faith.
No, faith may not fail if your lordships go through the facts.
As it is, you are participating in the proceedings.
Yes,
So,
I cannot have faith, because
So,
the
as
bias
it
is
is-
large.
Mr.
I cannot
Roy,
have faith.
Mr. Roy, I am absolutely, vocal in whatever I am thinking.
Yes, ma'am. We are aware
So
of
you know that what am I going to do? If you want that order, I will pass it right away. But if you want that more circulars, more things to be considered, more points to be considered, interplay of the circulars and the rules and the various decisions of the board, railway board, etc. are to be
Your
considered.
lordship may say,
I will say everything.
Your Lordship may say that I'll be allowed to place all the circulars.
Yes, yes, why not? It's your right, Mr. Roy. They have.
No, they do not, Madam. They do not.
They will.
They
Will
do
you not consider?
They do
Madam,
not
it never
proceed.
happens, madam.
They are-
Everything which is being supported by anything, madam, that is being decided by the.
It
They
will
are-
be, and it will be supported by an order of this court.
Yes, sir. That's why I wanted.
So
Your
we will
Lordship-
give you
that's why
that
I
order.
requested that Your Lordship
We
may
will
say
give
that.
you that order. But you agitated. The matter is still pending.
Yes, sir. It's still pending.
So this particular issue is itself and a distinct issue altogether on the point of jurisdiction, isn't it? You consider it. You consider this point of jurisdiction,
Yes, madam, that can
and the
be,
final
madam.
order will incorporate this point also on the
That-
point of jurisdiction.
That can be, madam, there is no difficulty.
Now, what do you have to say? That's it.
That can, madam, so far as that part is concerned, your Lordship, one thing, madam, I intend upon to submit before your Lordship, so far as 152.1 is concerned. My learned friend is harking upon with respect to the appointing authority. But here the provision itself speaks about, madam, any authority otherwise empowered.
Mr.
No.
Mr. Anil Kumar, we are not. He is not at this stage inviting an interpretation because
Then,
he
madam,
knows how am I going to
then will
interpret.
not, then will not be a
So
possible.
therefore, I don't want to non-suit him on this point.
Then,
There
madam,
could be some grey area
Yes, madam.
that may require some consideration, some circular here or there. That
No, the
opportunity you should have.
rule
He is
will
in.
not- that
Otherwise,
rule-
also he is in a soup.
ठीक.
So that would be better.
Your Lordship, it's fair from Your Lordship, and it's a very complex question of law, madam, to.
No, no. Complex question of law is to be
It's a
decided by
complex
its
question.
jurisdiction.
It's a complex
But
question.
there are interplay of so many rules and circulars, and therefore it is
It is
an
only the
issue.
court which is competent to interpret, madam.
Certainly.
These officers or not.
If you want interpretation, I will interpret it right now. We are not shying away from it or from passing a judgment, and I have never. Then you will have to contest this point before LPA. I hope you succeed. Otherwise, before Supreme Court, and this disciplinary proceeding is not going to stay like this.
Your Lordship may say that they will decide the issue of the.
I will certainly say so.
And they will provide me opportunity of very.
Everything they will.
Documents which I have sought for, they will say so.
If not
You will
provided,
make an
then
application, madam.
If you make an
I cannot
application-
ignore
I have already made it, that is part of the rejoinder, it will also, madam. I have already made.
देखिए WPS number 3734 of 2023. Would you withdraw?
No, Your Lordship, withdrawing was a problem to us.
No problem.
And moreover,
Heard
so
the
plans are
learned counsel
important.
for the parties. The learned counsel for the petitioner has submitted that the impugned charge sheet has been issued.
Madam, before
By
your
an-
Lordship proceeds, madam, one thing I intend to put something before your Lordship, madam, in the charge sheet, madam, which has been issued by the friend was harping upon that it has been issued by an ad hoc authority, madam. Can we see for a moment, madam? Annexure 1, page 22. Madam, this is Sahayak Suraksha Ayukt, simplicity, madam. The ad hoc charge, madam, nothing has been mentioned. In the rejoinder, madam, they have come with one notification of 2017. When he was posted at that moment of time, that is at page 47, his name is appearing at serial number 9, when it has been said reported on 16/5/2017 and posted on promotion in junior scale Purian ad hoc basis. This letter was issued in 2017, 12/4/2017. Here, we are in 24.
The present status is also not clear.
Yes, that is not clear. On that basis, it cannot be said he was an ad hoc
That's-
authority.
They should have brought on record if they have been.
You have produced
Yes,
it in
same in
rejoinder for the
rejoinder
first
itself.
time. यहाँ तो सारा केस रिजॉइंडर में पहली बार
रिजॉइंडर में पहली बार लाए हैं तो हमको तो काउंटर में तो हम दिया ही
झारखंड
नहीं
हाई कोर्ट का पिक
और मेन पिटीशन मेन ऑर्डर में भी
All
नहीं
the
लिखा
cases
हुआ
are made up only in the rejoinder.
इवन द मेन पिटीशन दिस हैज नॉट बीन रेज्ड
Heard the लिखिए this writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the disciplinary authority as well as the appointing authority of the petitioner is respondent number 5, and the charge sheet has been issued by an incompetent authority, that is by respondent number 6, who at that relevant point of time was in charge of the same post. For the purposes of stating, ad hoc, was working on ad hoc basis. In order to state that the respondent number 6, the incumbent of respondent number 6 was working on ad hoc basis, the Learned Council has relied upon a notification annexed with the rejoinder, which is of the year 2017. However, no plea with regard to the fact that respondent number 6 was working on ad hoc basis has been raised in the main writ petition. The Learned Council has relied upon Rule 153.2.1 to submit that the disciplinary authority Rule 153 to submit that the procedure for imposing major punishment has been prescribed and has referred to Rule 153.2.1 to submit that the procedure for imposition of major punishment can be initiated by the disciplinary authority, who could be the respondent number 5 but not respondent number 6.
So far as ad hoc basis is concerned, there is an amendment in the writ application at para 40.
इसको हटा दीजिएगा government in the writ petition. The Learned Council has further referred to Rule 25 to submit that the powers and the general powers and responsibilities of superior officers have been provided under the rule, which in turn refers to Schedule 2 to Schedule 4. The Learned Council has also referred to Rule 151, which deals with the disciplinary authority, and Rule 152 dealing with the authority to institute proceedings. He has referred to Rule 152.1. He submits that the charge sheet does not conform to the provisions of Rule 151, 153 and 152.1, read with Schedule 2 and Schedule 3 of the aforesaid rules. The Learned Council, while referring to Schedule 3, has submitted that the power of dismissal cannot be passed by the Assistant Security Commissioner / Assistant Commandant of RPSF / Adjunct. Rather, it can be passed only by the Divisional Security Commissioner / Security Commissioner Commanding Officer / Senior Security Commissioner. The Learned Council has also referred to the Schedule 2 to submit that the appointment, the respondent number 6, the authority of respondent number 6 has no power of appointment, and therefore respondent number 6 is neither the appointing authority, nor the disciplinary authority, nor any order of dismissal can be passed by respondent number 6. However, during the course of argument, it has not been disputed by the Learned Counsel for the petitioner that there could arise a situation where a proceeding for major penalty has been instituted, but it ultimately culminates in passing of a minor penalty, minor punishment. The Learned Counsel has also relied upon a judgment passed by Honorable Gujarat High Court in Satish versus Union of India in case number C/SCA/7466/2019 and has referred to paragraph
Equivalent citation would be 2020 SEC online, Gujarat 737.
2020 SCC online
Gujarat 737.
Gujarat
737.
737 लिख लीजिए 2020 SCC online Gujarat 737 and has submitted that while dealing with Schedule 3, the Honorable Gujarat High Court has held that it was apparent from the rules mandated for proceedings that the disciplinary enquiries are to be initiated by the disciplinary authority only. However, the learned counsel, upon a query made by this court, could not point out from the judgment passed by the Honorable Gujarat High Court with regard to consideration of Rule 152.2 of the aforesaid rules. Correct? मिले तो बता दीजिए.
है
बताइए,
पेज 44 पे है,
बता दीजिए.
पेज 44 पे है 152.2
पेज
44 of the complaint.
40.
He has quoted 152.2.
It is just a quotation. Consideration is another
Yes,
thing.
that's why I was saying that 152 has been taken care of by the
Not consideration and interpretation तो नहीं है ना उसमें.
interpretation.
Interpretation लिख दीजिएगा. With regard to Rule 152.2, the learned counsel has also submitted that there are also circulars and rules of the Railway Board which would indicate that the respondent number 6 was not having the necessary jurisdiction to issue the charge sheet. He has also submitted that those rules and circulars are to be read with the aforesaid rules. ये रूल का नाम लिख लीजिएगा. Railway Protection Force Rules 1987. The learned counsel appearing on behalf of the respondents while opposing the prayer has referred to Rule 152.2 to submit that a disciplinary authority, that as per the said rules, a disciplinary authority competent under the rules to impose any of the minor punishments may institute disciplinary proceedings for the imposition of any of the major punishments, notwithstanding that such disciplinary authority is not competent under the rules to impose any of the major punishments. The learned counsel has referred to the schedule to submit that the minor punishments including and also reduction in rank or grade can be passed by the authority of respondent number 6.
With the regular appointee which we have replied in paragraph 54.
Yes, the learned counsel has referred to paragraph number 54 of the counter affidavit. The learned counsel has also submitted that initiation of disciplinary proceedings is different from passing of the final order. The proceedings under major punishment may culminate into passing of a minor penalty and the provision of Rule 152.2 is peculiar to the Railway Protection Force Rules 1987, and the authority of respondent number 6 is backed by the rules of 1987.
Lordship may say, well, my contention is that it is applicable to the circumstances.
Sorry?
152.
Okay, exactly. The learned counsel further submits that if the petitioner wants to rely upon further provisions of the rules of railway board or any circular, these aspects of the matter can be appreciated by the disciplinary authority, by the authority who is conducting the inquiry. Pursuant to the charge sheet issued to the petitioner, the petitioner is already participating in the inquiry proceedings, but by virtue of interim orders passed by this court, no final order has been passed. The learned counsel submits that the point regarding the jurisdiction of respondent number 6 to issue the charge sheet would require consideration of various circulars, etc., which can be placed by the petitioner and the concerned authority before the inquiry
This
officer.
submission should be recorded in the name of the petitioner.
Yes, that is.
That I'm already.
Yes, so probably my lord was recording the statement on my behalf. my lord.
Okay. Okay. अब आपकी तरफ से है ना? After hearing in response, the counsel for the petitioner has submitted that the petitioner is a gazetted officer.
No, petitioner, this second part of 152.2 is applicable to gazetted officer. I am not a gazetted.
That is not mentioned in the ruling.
ऐसा चीज मत लिखो।
रेलवे बोर्ड तो वही दिखाना चाहता है।
नहीं, that
नहीं,
cannot
ऐसे
be
नहीं,
done.
ऐसे नहीं हो सकता
Then I
है। जब
propose
when
that-
things are being kept open, then to a great extent we cannot go beyond that.
That is my submission. Submission में लिखा
नहीं,
है।
इस तरह का submission नहीं है।
That rule does not speak about that.
When the
मतलब
rule
that
is not
cannot be
referring to
added.
gazetted and
That
non-gazetted.
cannot be
I
added.
was only saying my submission, not finding of the rule.
That is not mentioned in the rule.
Please,
my
you
lord.
cannot dictate the
No,
order
I know,
in the
I know,
manner.
I was only making a request.
Yes, please open. बस वो सब नहीं लिखाएंगे. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that there is a dispute in connection with the jurisdiction of the respondent number 6 in the matter of issuance of charge sheet. This court also finds that the petitioner is not only relying upon the aforesaid rules of 1987, but certain rules framed by Railway Board and also the circulars which may be applicable upon the petitioner. This court is of the view that the circulars that not only the circulars which are being harped upon by the petitioner, but there may be other circulars also which may throw some light in connection with the jurisdiction of the respondent number 6 apart from the provisions of the aforesaid rules. In such circumstances, this court finds that the point of jurisdiction of respondent number 6 is itself a mixed question of fact and law, and therefore at this stage this court is not inclined to decide the point of jurisdiction authoritatively. However, the fact also remains that the petitioner is participating in the disciplinary proceedings initiated by the respondents, and the proceedings has not yet concluded. Therefore, it will be, and thus the petitioner is proceeding simultaneously in the present writ petition as well as before the disciplinary authority. In the aforesaid facts and circumstances, the point regarding jurisdiction can certainly be raised before the respondent even at this stage, and therefore while not deciding the issue of jurisdiction under 226 of the Constitution of India at this stage of the proceedings, it is left open to the petitioner to raise the point of jurisdiction along with the supporting circulars, rules, etc., which the petitioner may rely upon before the authority within a period of 15 days from today. Upon raising such issue, the concerned authority shall give an opportunity to the concerned representative of the respondent and pass an order on the point of jurisdiction
Also,
along with also while passing the final order in the disciplinary proceedings. The matter has remained pending at the hand of the respondent authority by virtue of interim orders passed by this court. Accordingly, the respondents are directed to expedite the proceedings and conclude the same within a period of 4 months. 4 months from the date of communication of this order.
Lordship may say, what is the documents which I have sought for?
Yes. If it is further observed that the petitioner has also raised a grievance with regard to non-furnishing of certain documents, if any such, if annexed with the charge sheet,
Not with the charge sheet. They have subsequently they have given list of documents. They have furnished with certain list of documents, some of it and some annexures. That annexures are not.
okay, he has submitted that that a list of documents has been furnished, but the annexures to the list has not been given to the petitioner. If the petitioner has not been given the required documents, if not already given, be also furnished to the petitioner within a period of 15 days, the petitioner would give a list of the documents which the petitioner is requiring from the respondents. That's it. ये रूल अभी तक इंटरप्रेट नहीं हुआ सुप्रीम कोर्ट से.
क्योंकि that rule cannot be superseded by circular. That cannot.
हम तो अपना माइंड डिस्क्लोज कर दिए थे. तो सोचे नहीं इनका जान.
Now the matter as you over Milord, I have not placed upon Milord, but your lordship take into consideration the rule which my learned friend was lying with respect to the railway rules, Milord. The railway rules, Milord, if at all that is to be applied, then this provision will not affect, Milord, so far as that part is concerned. That is a separate proceeding.
No, 117 says, madam.
This 117 says in absence of that.
हमको समझ में आ रहा है आप लोग वहाँ कितना लड़ेंगे. चलिए, the state petition is accordingly disposed of. ऑर्डर अपलोड होने का वेट मत करिएगा. हम कोशिश करेंगे छुट्टी के पहले हो जाए. हाँ
2 weeks बोला है, वो 3 weeks कर देते हैं. 1 week क्या होली है कुछ होगा. 3 weeks.
ठीक है. फॉर फाइलिंग योर एप्लीकेशन 3 weeks. पंकज जी उसमें 3 weeks कर देंगे, है ना. इनिशियल जो ये फाइल करेंगे ना.
This case item 42, WPS 4886 of 2023.
I'm also prepared one relevant paragraphs of judgment to be relied by the petitioner. I have also prepared 2 soft copies of 1 Word file and 1 PDF through pen drive. And on the last occasion, I have given 1 short notes. I have added 1 particular paragraph in the that short. Only 1 paragraph as my solutions.
You see, you need to place these judgments.
Yes, Lord, it has already been placed, Lord, on last occasion, Lord, and the compilation was already given to your edition. So
This
first,
is your note.
No, my note. No, that is my short notes. Only I have updated.
Revised.
Only 1 paragraph last I have added. Only last paragraph. With respect to that, the diploma holder has only 1 chance. That is junior engineer post. However, the assistant engineer has many chances. Like direct BTech degree holder has chances like assistant engineer post and other post. If they will occupy our post, then
ये
we will
पहले
get
वाला है.
it. नहीं ये अभी
अच्छा
है।
आप दें.
I'm right.
Just
You have the response straight on.
yes. What is your stand?
My lord, whatever I had placed, your lordship, mine is a limited scope. That
Kindly place it once.
my lord. After giving the background, your lordship, the page 5, case for the respondents. The minimum education qualifications for post in the said examination rules and also in the advertisement have been fixed in accordance with the provisions laid down in the Jharkhand Junior Engineering Cadre, Junior Engineer Civil Electrical Mechanical Service Rules 2013 as framed by the Road Construction Department, Government of Jharkhand, vide its qualification number 377 dated 16/1/2014 as amended by the notification dated 21/1/22 and notification dated 24/23. The Rule 9 of the Jharkhand Junior Engineer Cadre, Junior Engineer Civil Electrical Mechanical Service Rules 2013 fixes the minimum technical qualification for appointment on the post of Junior Engineer. Rule 9 has been following provision with respect to minimum technical qualification. Diploma or equivalent in civil/electrical/mechanical engineering from institutes established under law and recognized by the central/state government or from institutes recognized by the All India Council of Technical Education on the last date of application advertised by the Jharkhand Staff Selection Commission. Higher technical qualification holding candidates will also be eligible for application. The interpretation of higher technical qualification is concerned, the same can be clarified by the Road Construction Department, Government of Jharkhand, as the service rules for the advised posts have been framed by the Central Road Construction Department, Government of Jharkhand. That is my limited submission, Your Lordship. There cannot be a dichotomy between the original service rules and the examination rules. That is my limited submission. And the original service rules have been framed by the Road Construction Department. They were a necessary party to these proceedings. In this case, they have to be heard before final order is passed. After that, I place the relevant paragraph of the judgment.
The results have been kept in abeyance. Why is counteracted? Sorry?
Results of the calendar. Exam.
Who is respond number 5 and 6? You are representing
Yes,
5 and
yes,
6?
yes, yes. I will stand with the paragraph number 8 and also that the JCSC is the examination conducting authority and it has to conduct the examination as per the requisitions by the postal department and the advertisement was made on the basis of the requisitions sent
What
by
is
the-
your stand in para number 13?
I will also
You read para 13 please.
It is only stated and submitted that nowhere has it has been mentioned in the recruitment rules that only candidates with higher technical qualification in the same channel, that is those having higher technical qualification after having diploma in the same stream only will be allowed. The respondent commission has published its advertisement in consonance with the requisition, the recruitment rules.
So as per your interpretation, it need not be in the same channel.
Yes, course.
This is how you have interpreted.
Yes, course.
Maybe you are the examination conducting body, but this is how you have interpreted.
As per the requisition made by the
That's
rules, so para 14 we have stated that the matter of formulating recruitment rules rests with the state government, and the responding commission as the recruitment arm of the state government accepts and adopts the reply.
That's right. Notice para number 18 of the counter affidavit filed by respondent number 4, Secretary Energy Department. One writ petition was filed by Rahul Kumar and others.
That was dismissed as withdrawn.
That's right, but they were challenging the eligibility criteria only.
I have
Who is the
information.
petitioner here? You are
He's a
Rahul
different
Kumar.
one, but I am aware about that writ petition. Earlier, before this advertisement, another advertisement of JH has
Same
come.
nature.
Same nature, same writ was filed, but that advertisement was withdrawn by JSSC because some fraud and hacking was happened and there was an inquiry and FIR was registered. So that advertisement withdrawn, hence that writ picker influxes, that withdrawn. Again, the fresh advertisement come and for this writ petition.
For the learned counsel for the parties. How urgent it is to pronounce a judgment in this case?
Just now I have been informed that results are 2 days ago results are.
The results are already out.
Yes, results are.
So,
When the successful candidates, circumstances, at least in a representative
we
capacity.
do not know.
No, no, there are
Things which
judgments
are
to
not
that
on
effect.
record. Neither you have brought it on record, nor they have brought it on record. But certainly these rules will be interpreted.
Yes.
We are not going to, by your evasive counter is not going to serve that. The chief secretary is a party here. We don't bother about your department, not department. We are not concerned.
Probably,
And the other thing is, when the rules are clear, you don't need any backup files to interpret the rules. When the rules are clear,
if
you don't need.
If the rules are clear, your lordship.
Yes, they are very clear. I have no doubt in my mind,
No, no, I have nothing more to say then.
in my judicial mind.
I understand
Of
that. I
course.
have nothing more to say. Then there's nothing.
ये जितना भी सबमिशंस है ना, आपने सबने सॉफ्ट कॉपी दे दी है?
मैंने sent the soft forwarding.
आप दे दीजिए भाई, कैसे चलेगा? इतना लोग टाइप करते करते परेशान हो जाते हैं, ठीक है? ये दे दीजिए। और आपका?
I will send it on WhatsApp. I don't use a pen drive anymore. I've had bad experiences with viruses and मतलब हमारे कंप्यूटर से आपके में आ जाए, हो जाएगा हाई कोर्ट के कंप्यूटर में डाल दिया हुआ है। तो मेल में I will forward it. I will forward it on mail.
ओके, यू फॉरवर्ड टुडे इटसेल्फ,
Today.
डू द नीडफुल टुडे। मेल आईडी इनको दे दीजिए, कौन से मेल आईडी में लेना है,
My associate will take it.
ठीक है? The counsel for the petitioner as well as the counsel appearing on behalf of the state have filed their written notes of argument and have also advanced their arguments on earlier occasions and also today. The learned counsel appearing on behalf of respondent number 5 and 6
Yes.
has referred to paragraph number 8 and 13 of the counter. 8 and 13 both? 8 and 13 of the counter affidavit. Start कीजिए please. Post this case for judgment on 6th of May. 6th May. ये पेन ड्राइव आपको मिल गया, आप बस काम शुरू कर दीजिए, ये सारा एक जगह कर लीजिए, इसको इनका रेलेवेंट वो, एंड देन वंस वी डू दिस वी टेक अ डिक्टेशन फ्रॉम मी एट द अर्लीस्ट। छुट्टी का शेड्यूल बता दीजिएगा, वी आर ऑल वर्किंग ड्यूरिंग वेकेशन। इसको टैग करें।
Item 23, criminal division 481 of the 2020.
In this case, compromise prisoner stands convicted for the offense of 138 NIA and thereby sentenced to under life for 1 year and fine. The amount given on jail.
So what happened?
So that thereafter, after dismissed, then we referred this revision and in revision application. But in the meantime, during pendency of the examination, there has been a talk of compromise going on in the
Your
parties.
provisional bail
Pursuant to
has expired on 29/2/2022.
no, it was last day, Thursday on 7th March. It was listed, but it could not reach. I was therefore bail was extended till 7th March.
7th
So-
March.
Well,
Today is what date?
but last Thursday when it was 7th, and on that day it was
Provisional bail has expired.
It is
No, there
In
is
view
no.
of the
There
talk-
is the joint compromise petition.
Well,
For last so many dates, you have been saying that negotiations are going on.
Pursuant to that,
It is
amount-
likely to be compromised. Where is it?
Pursuant to that, twice amount of 2 lakh has been deposited twice.
Twice
But when you
means.
have a look to the order dated.
Twice means what is the amount?
9 lakh rupees.
9 lakh. You deposit 9 lakh.
No, Lordship will kindly appreciate.
I am appreciating. Or you
the-
surrender. What do
He
you
has
want?
already deposited twice,
4 lakhs.
2 lakhs.
Is there any compromise going on between
Yes,
the
sir.
parties?
Yes, in view of that, my lord, I pray that it may be adjourned for further 4 weeks. In the meantime, there will be a compromise petition will be filed in between the parties. And my friend was also appearing on previous several dates, and they are also aware. Therefore, not for the
You have received 4 lakhs.
Yes.
look, the amount of the, that,
Compromise is going on and it is not going on.
Talk of compromise is
Talk means what?
अभी हो रहा है कि इसमें
पैसा
7 लाख
लेने के
देना है
बाद
कि 8
4
लाख
लाख
देना है कि 9 लाख देना
4 लाख
है
दिया है और बोला
चेक अमाउंट कितना है?
4,74,000 और दिया दे चुका है
7 lakh 74
already.
It's a check amount.
74,000 from
What is the compensation amount?
of but
9 lakh rupees.
so
9 lakh.
the matter can be compromised not in as per instruction of my client. He deposited 4,74,000 and now he is to pay 3 lakhs more.
नहीं 4 लाख ही
But
दिए।
then, apart from the judgment, that is the talk in between the parties. So, in view of the that he requires some more time. That is the therefore there is talk of compromise going on for several days. And in view
आप
of
भेज
that,
देते हैं
twice.
झालसा.
No,
आप
इनको
झालसा में जाके सेटल कर लीजिए. ये
इनको
सब
भी-
कहानी नहीं चलते रहे. I will send you to झालसा.
एक 4 हफ्ते के लिए फाइनल ऑफ टाइम दे दिया जाए.
हम आपको दे दे रहे झालसा में अपियर.
They are also aware of the
रांची का
facts.
लोकल है.
नहीं सिमडेगा
सिमडेगा का है.
तो वहाँ का डीएलए से बहुत बढ़िया काम करता है.
ना
अब
तो
जाइए.
यहीं पर हो जाएगा कुछ नहीं यहाँ पर
कहाँ पे हो जाएगा?
पिटीशन
कुछ
हम
नहीं
लोग
होगा.
फाइल कर देंगे.
कितना दिन से तो चल ही रहा है कॉम्प्रोमाइज का कहानी.
जॉइंट कंपनी पिटीशन हम लोग फाइल करेंगे. खाली सम टाइम इज रिक्वायर्ड फॉर managing the fund, rest of the fund which has been settled. And my friend is also aware about this fact.
If you are aware, then withdraw the case ना. जाके अपना कॉम्प्रोमाइज कर लीजिए.
So then the judgment will stand, and
Yes,
he
it
will be
will
at,
stand.
now he
He'll
will
go to
even
jail.
Lordship was saying that bail up to 7. So now
It will be better on the petitioner to
so,
withdraw this.
right. No, they are also aware of the facts that the compromise.
No, you see, it cannot go on like this. You go and appear before the District Legal Services Authority in Simdega and enter into terms of settlement. Or we will have a failure report. As simple as that. It can't go on like this.
Yes, I am also ready.
And
You also.
and Lordship will.
क्या दिक्कत है?
Lordship में pass हाँ ठीक है.
वहाँ जाने में क्या दिक्कत है?
Matter of bail that may extend.
वो बेल नहीं देंगे तो आप कैसे अपीयर होइएगा?
हाँ
ये
bail
भी
तो
तो बात है ना. बेल तो एक्सटेंड करना पड़ेगा. जो
बिल-
एक्सपायर हो गया
बिल-
पीरियड फिर भी कर देंगे.
DLS में
Simdega DLSA is very good. Go and
वहाँ से
appear.
compromise हो जाएगा.
जाइए, वहीं पर जाइए.
whatever will
Learned
be the
counsel for the
outcome.
petitioner and opposite party number 2 are present. It has been reported by the aforesaid counsels that talks of compromise is going on, but nothing has been crystallized so far. Counsel for the petitioner has submitted that huge amount has already been deposited before this court.
नहीं,
2 lakhs deposited.
4 लाख को मिल चुका है.
DD not दिया. First time 2 lakhs was given.
Mr. Mukhopadhyay, please शांति रखिए. आपको मिल गया
हाँ
है?
4 लाख रुपए.
Okay. Counsel
Check-
for
check
the
4 लाख रुपए मिला है चेक के द्वारा.
okay. The counsel for the opposite party number 2 has submitted that he has already received an amount of rupees
4 लाख.
4 lakhs, subject to the result of this case, and the check amount involved in the present case was to the extent of rupees 7 lakhs and odd, and the compensation amount was to the extent of rupees 9
9
lakhs.
lakh.
So
In order to आप लोग appear होंगे mediation में, right?
हाँ, हम लोग appear करेंगे.
The learned counsel for the parties have submitted that in order to expedite the process of settlement between the parties, they are agreeable to appear before the District Legal Services Authority at Simdega as both the parties belong to Simdega. Let the petitioner as well as the opposite party number 2 appear before the Secretary District Legal Services Authority on April 2, होली के बाद हो गया, on 2nd of April 2024 at 11 a.m.
Okay.
Upon their appearance, the Secretary District Legal Services Authority shall do the needful and submit a mediation report before this court latest by 23rd of April. Let the matter be posted on the latest by 30th of April. Let the matter be posted before this court on 9th of May 2024. The provisional bail granted to the petitioner earlier is extended till 13th of May. Let this order be communicated to fax.
What about, apart from 4 lakhs, my instruction is that he has paid some
आप जाके
cash,
वहीं पे बात
74,000.
अरे बात करिए ना वहाँ पर.
Now that is,
Mediation report will come, right?
no, तो ये भी हमारा
The counsel for the petitioner has also submitted that apart from rupees 4 lakhs, some cash amount has also been paid by the petitioner to opposite party,
74,000.
amounting to an amount of rupees 74,000.
Item 24, Conversation 495 of 2020.
Matter of distance, landlord below court below has granted maintenance of rupees 6,000 to wife and rupees 2,000 to the mother, and as is the income of the husband as rupees 65,000 per month. Well, kindly see the order dated 8/2/2024 passed in this case, right? 8/2/2024. Order number 4.
Yes.
May be permitted to, having learned also for the party, having considered the submission advance on behalf of the parties, it is found that it is a dispute regarding maintenance to be given by the husband of the party to his wife, petitioner and his child. It has been pointed out by the learned counsel for the petitioner that opposite partner of him is working in CCL, and as per the income order, his monthly gross salary is rupees 65,000 and only amount of rupees 8,000 has been awarded as maintenance for the wife and child, which is not in right proportion. Learned counsel for the petitioner has relied upon ruling of the Honorable Supreme Court in the case of Kallam Devi Chaudhary versus Rita Devi Chaudhary Nandi, reported in 2073 JCR 106 wherein 25% of salary was awarded as maintenance. In the present case, 25% of salary comes to the account.
What happened to this report has come?
No, mediation has already been paid, ma'am.
Alright, then you argue your case. You are there to OP number 2. Argue.
My lord, kindly see the judgment of the Honorable Supreme Court, my lord.
First, the impugned judgment.
Yes.
Date of marriage is 27 to. This is the only on the quantum of maintenance.
Only that is.
Let
Date
us
of
see. Is it a fact that your monthly, his monthly income
Yes, it
is
is admitted because
undisputed.
CCL employee, my lord, I have also annexed the payslip of present, my lord. At present, he has been getting 1,28,000 per month, and that time he was getting rupees 65,000 per month. They have not disputed the salary.
What was the claim?
Claim rupees 25,000.
25,000 per month was the claim, and
But granted only rupees 6,000 and to the wife and 2,000 for the children only, my lord.
Where is, read para number 12. Read
Now,
para number.
now the quantum of maintenance as per case of the petitioner, Dr. is an employee of CCL enjoying salary of ₹60,000 per month. Dr. has admitted his service in CCL but denied the getting of salary as stated by petitioner among 1. It is admitted fact that the Dr. got employment in compulsory government and he has been living with his mother and his brother's family. His elder brother died and he has moral obligation to maintain the family of his brother. However, it is settled principle now that object of the maintenance person not to punish a person for his past neglect, but to prevent that dismissal by compelling those who can provide support.
In a case of compassionate appointment, he is under an obligation to maintain the entire family.
Yes, yes,
Right.
my lord. लेकिन उनका conduct देखिए, उनका माँ को भी उनसे maintenance court के माध्यम से
वो
लेना
उसका
पड़ता है।
कंडक्ट से नहीं मतलब
नहीं नहीं,
वो
माँ को भी वो नहीं दे रहे हैं maintenance।
नहीं दे रहे होंगे
तो
तो माँ
इस-
भी केस करेगी इनके
हाँ,
ऊपर. We are not bothered
केस किए
about
मिल भी रहा।
मिल भी.
Yeah.
So now the point is,
So as per the judgment of the
what is the age of the child
child 12 years?
studying in school?
Yes. 2000 मिल रहा है मान लो, आधा लीटर दूध भी नहीं मिलता है 2000 में। 1 लीटर दूध के लिए 3000 रुपया लग जाता है आजकल। मान लो इसमें जजमेंट है माय लॉर्ड्स, ऑनरेबल सुप्रीम कोर्ट ऑफ इंडिया का, जिसमें
When this case was filed,
हाँ.
please hold on. When this case was filed, at that point of time, the child was only 6.5 years of age. Now she has also grown.
ये 12 years.
Maybe that the requirement of money has also increased. His salary might have also increased. In order to alter the maintenance amount, you have a remedy under 127,
Yes.
right? But so far as this quantification is concerned, when he, as per the impugned order, has to maintain his mother and the wife and the family of his brother.
Yes, my lord. But
Right.
as per the Honorable Supreme Court of India, my lord, at least 25% is maintenance is entitled for. The wife is entitled for at least 25%. My lord. Paragraph 16, my lord.
Now,
इसमें my lord,
just a
जिस
moment.
जिस जजमेंट के बेसिस में ऑर्डर पास हुआ है 1973 सुप्रीम कोर्ट केसेस पेज 129
73.
1970 वॉल्यूम 3 एससीसी पेज
1970 में है आप अभी.
नहीं इस केस में जो पैरा 16 में जो
अच्छा.
केस का रेफरेंस है उसको देखा जाए, उसमें 25% दिया गया है वाइफ को और 15% दिया गया है सॉन्ग पैरा 7 में।
Mr. Counsel, you tell us one thing. In the impugned order, the consideration for quantum of maintenance is that he has to maintain his mother and his elder brother died and he has moral obligation to maintain the family members of brother. How does this moral obligation will be given preference to his legal obligation to maintain his wife and child? No, show us one thing, that this moral obligation will be an impediment in the way of the petitioner to claim adequate maintenance.
Well, that has been recorded as moral obligation, but in fact, my lords, it is a very condition on which I got a job. Now, may kindly see the affidavit that I have.
We are not concerned with your affidavit.
But my affidavit was shown, it was given by me. And
Where was it given?
Now, may kindly see my counter affidavit.
No, we will not see counter affidavit. We will see the records. We are in revisional jurisdiction.
Well,
Nor we will see your enhancement of income, nor we will see his or your any affidavit, right? Once the brother is dead,
His brother
elder
had,
brother, that too.
he had given an affidavit, no objection to me that I got a job in place of him.
Okay.
Now he died, my lord.
So?
And he has almost 8 children, my lord.
No, he may have 1 dozen children. How is your wife concerned with that?
My lord, let us,
No, you just see, he gave no objection. But was it a condition that he has to make, that you have to maintain him and his family?
my lord, in the affidavit may be seen, my lord, that I had sworn.
That was not a part of the records. You see that the order requires requantification.
My lord.
And
My lord,
this
there is one point with
requantification.
respect to the quantum, my lord. My lord, may kindly see page 19. One of the deposition is there, my lord, in the brief, page 19. This is one of the witness from the side of my lords, आवेदिका की तरफ से गवाह था, my lord. What he has stated.
What has he stated?
It was his witness, my lords. Page 19 may be seen.
Page 19 of the main petition?
Yes, my lords. Page 19.
Yes.
My lords, para 20 from para 27 onwards. विपक्षी और आवेदिका 4-5 वर्ष से अलग रह रहा है. विपक्षी और आवेदिका अलग होने से पहले नहीं पढ़ता था क्योंकि छोटा था. विपक्षी और आवेदिका. पारा 29. यह बात सही है कि आवेदिका एवं विपक्षी के अलग होने से पहले इन दोनों का बेटा डीएवी स्कूल में पढ़ता था. पारा 35 मिनट्स. बच्चे का पढ़ाई लिखाई का सारा खर्च विपक्षी उठाता था. और देन मिनट्स नेक्स्ट पेज. पारा 31. यह बात सही है कि विपक्षी अपनी पत्नी के लिए विदाई के लिए केस किया था. आज भी विपक्षी अपनी पत्नी को रखने को तैयार है, लेकिन आवेदिका विपक्षी के साथ जाने को तैयार नहीं है. So my contention is that I was bearing the expense of child's education, that I am still willing to do.
So you bear the expenses
But
directly
I'm-
to the school. You pay the money directly,
Yes,
to,
directly
the
to the
school.
school,
So far
ma'am.
as the
Madam,
child is concerned.
I am ready to do that. With respect to the child, I will do that. Earlier also I was doing, now also I am willing to do that. But ma'am, with respect to the wife, my lords, I have just submission that I have to maintain my mother also. The 8 children are there, my lords, of my elder brother. All
That
have
is
to,
not your
some of them are,
responsibility.
my lords,
That is not your
my
responsibility.
affidavit is there on record, my lords. I had
You
given
are,
this in the
she is not bound by your affidavit. You
Ma'am,
see,
the-
if you get, if one of the brothers give no objection, that does not mean that the brother did not have any source of income. Your affidavit will not bind her. You have first
and ma'am,
responsibility.
she is deliberately not residing with me.
My lord,
You
kindly
are
see the
not
Annexa
challenged this
3, my
order.
lord.
That-
Where
that is the
section
mistake
9
that I have
application
You are
has
not
already been
challenged this order.
dismissed. Annexa 3 is the judgment passed in the under section 9 of the Hindu Marriage Act. my lord.
Where is it?
Annexa 3 page 46. my lord. 46, Annexa 3, page 46.
This is restitution.
Yes, that has been dismissed, my lord.
That has been dismissed.
Yes.
So,
But it is, the deposition has been, is of one of the witness from the side of the petition only.
restitution has been dismissed. Just imagine.
And not in the affidavit that I had shown, there was clear cut para, my lords. यह कि मैं इकरार करता हूं कि नौकरी पाने के बाद मैं पूरे परिवार का भरण पोषण करूंगा तथा छोटी बहन कुमारी पंचनामे का शादी भी अच्छा लड़का देखकर करूंगा. Also on this ground I got this service.
छोटी बहन का शादी कर दी है?
But as per the information is that.
This affidavit was exhibited before the court. No.
That.
What about the finding with regard to agricultural income? There was also a plea that you have agricultural income.
There is no such finding. That has not come.
That has not been discussed.
Yes. I don't have any agriculture.
चलो पेज 40 देख लेते हैं मैम। बोल रहे हैं बार बार कि हम मेंटेन करते हैं मार्क को। चलो पेज 40 उन्हीं का डिपोजिशन पेज 40 पैरा 3 पत्नी 2016 से अलग रहती है। लिख रहे हैं कि मैंने अपनी पत्नी के कहने पर अपनी माँ का भरण पोषण देना बंद कर दिया था, जिसके चलते मेरी माँ द्वारा भी एक भरण पोषण का मुकदमा संख्या 170/18 दाखिल किया गया था, जिसमें मुझे माँ को भरण पोषण देना पड़ता है। बोल रहे हैं कि कंपल्सरी अपॉइंटमेंट के चलते उनका ड्यूटी बनता है, तो वो ड्यूटी भी तो नहीं निभाए।
$65,000 का 25% कितना होता है?
करीब 16,000 उसमें आया है। आपका लास्ट ऑर्डर में आया है, ऑर्डर डिटेल ऑर्डर नंबर 4 में आया है। ऑर्डर डेटेड 8/2/2024 में।
Heard the learned counsel for the parties.
Plus there's one more thing. There are 5 daughters of my elder brother. All have to be maintained by me, my lords. For the sake of argument, my lords. For sake, my lords, I do not maintain them, my lord. They will all file Section 12 application against me under DB Act, and all will get separate maintenance, my lords. Well, that will be, well, if this amount of increase, my lords, I have to maintain 5 daughters of my children. All need to be married, my lords. Well, it will.
Your daughters are your liability.
But they have to be married, my lords. They have to be taken care of. When my lords, 25.
Everybody has to be taken. Why do you have to say so many times 5 daughters? They are not your liability. They are your assets.
But my
Isn't
lords,
it?
but my lords, all expenses have to be. If 25% fund my lord, money is taken by only by the petitioner, all those family members will suffer, my lords. The grievance of the petitioner
And
is
how
that, my
will
lords, I am taking care of
your
them,
child survive?
my lords.
In
I am-
2,000 rupees he will survive.
my lords, I will directly pay the fees of that my child in the school, my lords. That order may pass. My lords. The whole grievance is this, my lords. See, the petitioner do not want me to maintain them.
And what is your present income?
Well, it must have increased by the time, my lords.
सैलरी स्लिप लगाए हैं मैडम।
It is not 65,000 now, my lords.
1,28,000 ग्रॉस सैलरी।
That varies every month because when some wages are there in sale, but it is more than 65,000 now.
नेट
That-
पेमेंट
that I agree.
85,090।
For that matter, they have a remedy under 127. my lords, one para 34 में, page 34 में also we see my lord the deposition of petitioner my lords. At page 34.
We are only on quantum, we are not going to enter into your other dispute which you have not challenged.
She says that she will not go with me, she will not allow the child to go with me.
You have not conducted yourself well. A person who
Or
is
she
in
has never
government
filed, she has never filed a case against me under any 498 or this.
that's you should be thankful to her.
Because my lord,
This
she
shows
is not
that
with,
this shows that she is a perfect lady. She has not filed any case against you.
because my lord, there is no harassment, no.
There is an allegation of harassment.
Now she has stated मैंने प्रताड़ना की कोई
Anyways,
शिकायत थाना
whatever
में
it
की है.
is, your petition for restitution of conjugal rights has been dismissed.
Yes.
Right? So you now there is a decree in her favor enabling her not to go to you.
And she has stated that मैं अपने पति को कभी तलाक भी नहीं दूंगी और उनके साथ रहूंगी भी नहीं. So my lord, that is a very peculiar thing. My lord, neither she will live with me nor she will give me a divorce. That she has stated in her deposition. Just my lord, she wants the maintenance and do not want to discharge the marital obligation. That has all come in her deposition at page 34.
Had you been unemployed,
No.
had you been unemployed,
Yes.
then also this amount of maintenance was fit to be granted. Had you been unemployed,
In that case.
right?
Had I not required to maintain my elder brother's wife, my lord, she would have been entitled to more. In that case, I would have no objection. But still, I have to take care of almost 9 to 10 family members. There are almost 10.
Your name is Radheram Manji.
Yes, sir.
Where is the no objection of your brother?
In my affidavit that is with part of counter, I have maintained that my brother has given no objection.
Where is that no objection?
Was
Does that no objection mean that he will not earn? And
he
you
has
will-
died, my lord.
He has died later on, no?
Later on, now I have to take care of entire family. I have stated that in my complaint, policy.
What are your the daughters of your brother doing?
That's specific information.
What is their age tentative?
Tentative ballots, what I inquired was around two or three are around 20s.
They are also capable of earning, isn't it?
Specific details I don't have ballots. What is their degree ballots, what they do. But there were total ballots 8 children of my elder brother who died.
From where do I get this?
Was in my counter I have mentioned, para 7. I have mentioned the names also.
But age you have not mentioned.
My also direct I will file Aadhaar card of each
No,
one.
no. The quantum of maintenance is required to be refixed. The reason being that you have also alleged that the petitioner is also doing some work we do not know. Some embroidery work or whatever, she has some source of income, we do not know. She has also alleged that you have agricultural source of income. she might not have been able to produce any proof. So the required affidavits are required to be filed, but in the meantime, you will have to continue to pay this maintenance.
That is being done, but that automatically from the salary it is being deducted. There is no area of maintenance.
इसमें से 3 जन का शादी हो गया है, सप्रेस कर रहे हैं।
Just hold on. You see, now the amount, so far as the quantum of maintenance is concerned, you can always seek an enhancement under 127. Right?
है, तो हम 128 के ऊपर हम मांग सकते हैं कि अभी जो करंट सैलरी है, लेकिन मेरा ग्रीवांस है कि 65,000 में भी हमको कम दिया गया है। उसी का मेरा केस है कि 65,000 का जो 25% है वो भी नहीं हो रहा है, और इसमें से ही मैंने सप्रेस कर रहे हैं। एक्चुअली सब कोई मेजर हो गया है लड़की लोग, 8-3 जन में से उसमें से मैरिज भी हो गया है। वो स्पेसिफिक एफिडेविट इनसे ले लिया है कि किसका किसका मैरिज हो गया है, किसका कितना एज है, क्योंकि सब मेजर है।
You see, therefore, once you know that at the relevant point of time when this case was filed, they might have been minor, but now they have all married.
All married, ना?
Three of them
married. तो ये ज़्यादा दिन का केस नहीं है, मेंटेनेंस केस है।
2018 में
2018 का है।
almost 6 years.
8,000 2,000 बच्चा के लिए उसमें एजुकेशन, फिर खाना। अब जो 1970 का जो जजमेंट है माय लॉर्ड, आई हैव गिवन माय लॉर्ड, एज पर दैट जजमेंट माय लॉर्ड, 25% इज एंटाइटल्ड, वाइफ इज एंटाइटल्ड फॉर 25% एंड 15% is entitled, son is entitled for 15%. Para 7 में.
if there are no other liability.
Yes. तो उसमें टोटल मिला के 40% हो जा रहा है। तो इसमें पैरा 7 में जो हुआ है उसको अफर्म किया है। पैरा 7 ऑफ द जजमेंट उसको अफर्म किया ऑनरेबल सुप्रीम। तो टोटल दोनों मिला के 40% मिलना चाहिए। तो उसमें से यदि उनका कुछ लायबिलिटी है तो कम से कम मिनिमम 25% तो मिलना चाहिए।
ये मॉरल ऑब्लिगेशन के बेसिस पे नहीं चल सकता।
Well, that is the
You might be having your moral obligation, but moral obligation के basis पे legal obligation को नहीं हम लोग undermine कर सकते। Widowed daughter-in-law has a claim over the ancestral property, but she does not have any claim on the personal earning of brother-in-law. Right? So this part of the order that you have a moral obligation and therefore that is not correct.
But that is not just a moral obligation, that is the very
We do not.
basis of my service terms.
No. That is not the basis of this.
Because this affidavit was given
The brother
to the
has
CCL ballots.
the finding is moral obligation. It is not talking about legal obligation.
Well, the finding, maybe they are ballots, the document says otherwise.
But these things are not there on record. लिखिए. Criminal Division number 495 of 2020. This petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner is aggrieved only by the quantification of the maintenance amount for the petitioner number 1, who is wife, and petitioner number 2, who is the minor son. Aged 6.5 years as back as in the year 2018. Filing के समय होगा ना 6.5 साल. The quantum of maintenance as fixed by the learned court is to the extent of rupees 8,000, 6,000 and 2,000 for the wife and son respectively. The learned counsel has submitted that the salary of the petitioner has been taken to be 65,000 rupees per month, and the respondent is the salary of the respondent, and the respondent is an employee of
CCA.
Central Coalfields Limited. The learned counsel has submitted that while fixing the quantum of maintenance, the learned court has taken into consideration that the opposite party was given employment on compassionate ground, and he was living with his mother and his brother's family, and that his elder brother died, and therefore the opposite party had a moral obligation to maintain the family of his brother. The learned counsel submits that the opposite party has a legal obligation to maintain his wife and child, and the moral obligation to maintain the family members of the deceased brother cannot be a ground to award a meager amount of maintenance of rupees 6,000 and 2,000 to petitioner number 1 and 2 respectively. The petitioner number 2 is a school-going child. The learned counsel submits that the learned counsel has relied upon the judgment passed by Honorable Supreme Court reported in 1973 SSC 129 and also 2017 in bracket 3 JCR 106 SC to submit that at least an amount of 25% of the salary of the opposite party for the wife and 15% of the salary of the opposite party for the child was required to be fixed. The learned counsel appearing on behalf of opposite party number 2, the opposite party has opposed the prayer and has submitted that the counsel for the petitioners has also submitted that in the meantime the salary of the petitioner has also increased to rupees 1.28 lakhs. The learned counsel appearing
Gross
on
salary.
gross salary. The learned counsel appearing on behalf of opposite party has opposed the prayer and has submitted that the opposite party was given appointment on compassionate ground, and after he got employment, his elder brother also died, and therefore he has a moral obligation to maintain the family of his brother.
I have a legal obligation, my lords, under
He
DBA
submits
if they are
that-
aggrieved person under section 2A.
The learned counsel has also submitted that he also has a legal obligation to maintain the wife and children of his deceased brother
Yes.
under the provisions of
Domestic Violence Act.
Domestic Violence Act. And therefore, the quantum of he also has a legal obligation to maintain his mother. However, during the course of argument and also from perusal of the impugned order, no order for granting maintenance to the wife of his elder brother or to the children of his elder brother has been brought on record. The Learned Counsel has submitted that no such order has been passed so far.
Yes.
मदर का था मेंटेनेंस का ऑर्डर,
पेज 40 में खुद बोले हैं डिपोजिशन
देते हैं.
पेज 40 ऑफ द पिटीशन जो ऑपोजिट पार्टी का डिपोजिशन है, पेज 40 पैरा 10. Annexed to page 40, 4G.
The Learned Counsel has submitted that he had deposed before the Learned Court that under an obligation to maintain his mother, who does not have any other source of livelihood. Pension नहीं मिलता है.
As per my information, she is not.
The Learned Counsel has submitted that
I do not have any specific
he
instruction on that.
is not sure as to whether his mother is getting pension
Yes.
on account of death of his father, who was admittedly an employee under Central Coal Business.
Yes, sir.
Right? However, no order regarding maintenance to the family members of deceased brother or to his mother has been brought on record by the opposite party number 2, by the opposite party before the learned court, right?
But
After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the learned court has recorded a finding on the basis of evidences that the petitioners had sufficient reason to live separately from opposite party, and has also recorded a finding that the petitioners are entitled to get maintenance, and therefore the opposite party is under a legal duty to maintain the petitioners. While quantifying while dealing with the quantum of maintenance at paragraph 12, the learned court has taken into consideration that the salary of the opposite party was 65,000 per month, and it was though even that quantum was disputed.
was with respect to 65,000.
No.
What else?
But from the perusal of the paragraph 45 of the cross-examination of the opposite party the opposite party had stated that it was not correct to say that in spite of having income of 60 to 70,000 per month from CCL, he was not maintaining the petitioners. यही है ना? The learned court, while fixing the quantum of maintenance, has taken into consideration that the petitioner has an obligation to maintain his mother. The opposite party had got employment on compassionate ground, and he was living with his mother and his brother's family, and that the opposite party had moral obligation to maintain the family of his brother. This court is of the considered view that the obligation of the petitioner to maintain his wife and child, of the opposite party to maintain his wife and child, is not only a moral obligation but also a legal obligation. And so far as the amount of maintenance is concerned, only an amount of rupees 6,000 for the petition number 1 and 2,000 for the petitioner number 2 has been fixed. And the maintenance amount has been directed to be paid from 29 to 2020. And the ad interim maintenance, which was fixed earlier by order dated 26/6/2019, has been made effective till 28 to 2020. This court is of the considered view that the quantum of maintenance as fixed for the petitioner and for the petitioners is absolutely inadequate and calls for interference in the revisional jurisdiction, taking into consideration the salary as recorded in the impugned order as 65 of the opposite party as 65,000 per month. Considering the facts and circumstances of this case, This court is inclined to modify the maintenance amount to rupees 10,000 per month for the wife, petitioner number 1, and 5,000 per month for the son, petitioner number 2. The enhanced amount of maintenance हम यहाँ से नहीं एनहांस करेंगे, रिविजन में नहीं कर पाएंगे. I will not enhance, but for refixing the quantum of maintenance, I will remit it back. And you will continue to get this maintenance amount. कैसे होगा बताइए? Can I modify the quantum of maintenance
As per
here?
the judgment of the Honorable Supreme Court.
They have modified it.
Yes.
ठीक. The enhanced amount of maintenance would be payable from would be payable with effect from 29 to 2020. The arrears current कर दें?
The arrears may be paid in installments.
And the arrears of the differential maintenance be paid in equal installments of 15 months. Equal installments of 15 months. This order is without prejudice to the without prejudice to any application for modification of maintenance which may be filed by either of the parties. Right? This revision is accordingly disposed of with the modification on the quantum of maintenance. Yes.
I feel that serial number 32 may be posted for tomorrow because I have to withdraw that application by giving one order of the Honorable Chhattisgarh High Court. Only in pursuit of that order, I have to withdraw serial number 32.
You can withdraw without any
No,
observation.
that order must be come in the order sheet, Lordship, because the reference of that order, because there is the compromise between the same parties, and only in pursuit of that order, I have to withdraw as per instruction, as per the order also. And in the order that is indicated that the petitioner will withdraw his application filed before Honorable Jharkhand High Court. That's why, Lordship. So tomorrow we will post. We will see it.
Okay, who is for the other side?
And the other side, Shruti says, I will inform. I shall also inform. She was also waiting.
Do you want to withdraw
Milords,
something?
may I just mention serial number 26, Milords? Milord, in this case, Milords, by order dated 23rd of February,
Slip
Milords,
दीजिए mention.
Milords, by order dated 23rd of February, Milords, provisional bail was granted to the petitioner, which is going to expire on 21st of March, Milords. So I was only praying, Milords,
So you have taken a risk. You did not mention it.
Milords, because serial number चल रहा था, Milords, इसलिए हम
आपको लगता है कि पूरा लिस्ट खत्म हो जाएगा?
serial number 26, Milords, just one case after, Milords.
क्या है इसमें?
Milords,
NI?
498 है, Milords, husband है. Milords,
Compromise
OP2 had
petition
appeared.
file हो गया?
No, Milords, compromise पहले हुआ था, although अब जो है वो divorce case file की थी, divorce has been granted. She has now remarried. मेरे अगेंस्ट 494 का केस की थी, उसमें भी मेरा acquittal हो गया है. So I have a good case, Milords, on marriage.
गुड केस तो 498 से कैसे इससे क्या फर्क पड़ेगा?
नहीं, उस पे भी है, Milords, जो एक डेट को allege कर रही हैं, date of occurrence और एक medical report लगाई हुई है. Milords, from the exhibit from my side, from the side of the husband, it goes to show, Milords, that the date of occurrence itself is contradictory from her notice itself, Milords. वो कह रही हैं कि उस अपने इस complaint case में कि the place of occurrence was गया और लीगल नोटिस हमको भेजी है, उसमें कह रही है उसी डेट के लिए कि द डेट ऑफ जो प्लेस ऑफ ऑकरेंस है वो बोकारो में है और मेडिकल भी बोकारो
आपने उनको क्रॉस एग्जामिन किया है?
यस मिलोड, इस पे क्रॉस एग्जामिन भी हुआ है और मिलोड वन मोर फैक्ट इज दैट मिलोड जो मेडिकल
एलसीआर आया हुआ है?
नहीं मिलोड, ये
बिना एलसीआर के हम क्या देखेंगे? आपका क्रॉस एग्जामिनेशन का कहानी
दैट इज देयर मिलोड, बट ओनली मिलोड प्रोविजनल बेल वाज ग्रांटेड टिल 21st टू एक्सप्लोर द पॉसिबिलिटीज ऑफ सेटलमेंट.
सेटलमेंट हैज पेड?
मिलोड, सेटलमेंट हैड हैपेंड वे बैक इन द ईयर 2017.
अब तो हो ही नहीं सकता, अब तो दूसरा शादी हो गया.
हां एग्जैक्टली मिलोड, सो दिस
सेटलमेंट का मतलब परमानेंट एलिमनी भी तो होता है.
बट नाउ शी हैज मूव्ड ऑन इन हर लाइफ.
डिवोर्स हो गया?
हां, रीमैरिड मिलोड. उन्होंने ही डिवोर्स फाइल किया था एंड डिवोर्स हैज बीन ग्रांटेड मिलोड. आई हैव सर्टिफाइड कॉपी ऑफ द डिक्री एज वेल मिलोड.
इसको कल पोस्ट करिए, जरा देखते हैं क्या करते हैं. आप ऑपोजिट पार्टी की तरफ से? स्टेट की तरफ से. ऑपोजिट पार्टी की तरफ से
He had appeared on the last occasion. He was here.
Inform him.
I'll inform him.
Let us see what can
My
be
lord,
done.
my lord.
एलसीआर बिना देखे तो नहीं करेंगे ऑर्डर. कॉम्प्रोमाइज,
bail-
जॉइंट कॉम्प्रोमाइज फाइल हुआ है? नहीं हुआ है.
तो पहले हुआ था बट उसके जो टर्म्स एंड कंडीशंस थे उसको एडहर नहीं किया गया था, जिसके लिए हम नोटिस भी उनको भेजे थे. बिकॉज़ जॉइंट कॉम्प्रोमाइज में आया था कि शी विल विथड्रॉ ऑल दोस केसेस, बट वो नहीं हुआ था. दैट इज आल्सो ऑन रिकॉर्ड, दैट इज आल्सो एग्जिबिटेड द जॉइंट कॉम्प्रोमाइज
She
पिटीशन.
may choose not to withdraw.
नहीं, दैट इज देयर मिलॉर्ड्स, बट नाउ मिलॉर्ड्स एट प्रेजेंट कॉम्प्रोमाइज कैन नॉट टेक प्लेस बिकॉज़ शी इज नाउ रीमैरिड.
कॉम्प्रोमाइज का और भी मतलब होता है ना, that now you want to live peacefully. She doesn't want to pursue. और भी तरह से कॉम्प्रोमाइज होता है.
उसके लिए तो मिलॉर्ड्स फिर एक बार इनको मीडिएशन में भी भेजा जा सकता है इफ एट ऑल, बट अब डिवोर्स हो गया है मिलॉर्ड्स एंड नाउ शी इज रीमैरिड.
498A में
जी.
there is a concept of fine also.
No,
Right.
my lord.
You have remained in custody for some time.
3.5 months, my lord, out of 1
3 and a
year.
half, out of 1 year.
Out of 1 year.
So you can think of modification of sentence so that fine can be imposed
My
and that
lord,
can be
my
given
lord.
to her as victim
If at all it
compensation.
deems fits to your
This is
lordship's
also a
lord.
possibility,
My lord,
right?
my lord.
What is your client doing?
He is a practicing lawyer, my lord, at district court, my lord, in Bihar. Arwal, the district of Arwal. Arwal.
Ask him about it because we can think of doing that. It is very difficult. Then we may not call for the records.
My lord.
Then you will have to accept the conviction. Will
I
it have a
understand.
bearing in his practice? I do not know.
I'll ask him, my lord. I'll take
You
his
figure
He's
it
here.
out.
I'll ask him, my lord, and tomorrow if my lord will keep post this matter, I'll.
He has come to Ranchi.
Yes, please come to me.
He is quite serious about his case. I know. We'll figure it out, right? If he wants an acquittal, then under such circumstances we have to call for the records. Otherwise, it is not possible.
There are vital documents, my lord, which my lord will have to look into. If at all, my lord. this will
Revisional
be-
jurisdiction, you know how
My-
difficult it is.
My lord, that is there.
And figure it out if the wife is ready to settle. We do not know what kind of
But
settlement.
my lord, what kind of settlement will happen if my lord she had filed the divorce? Divorce has been granted. All the
She has filed the divorce because of 498.
on the ground of it's not that is I understand. my lord.
That's right.
Tomorrow.
दोनों कर दीजिएगा. और कोई मैटर है ऐसा? रिविजन वाले हमारे यहाँ डिस्चार्ज वाले कितने पिटिशंस हैं? They must have become infructuous by now. दिखाई जो लिस्ट में सारे एनआई एक्ट हैं.
नहीं मेंटेनेंस का भी
मेंटेनेंस में तो टाइम लगता है. There is an early hearing petition in serial number 30. Anyways, we shall see. It will not.
This for tomorrow. Obliged.